Do you think juries like this type of evidence or this type of testimony, or do you think they prefer to just look at it themselves?
I think it's helpful to summarize everything. I mean, let's not forget there's two very different stories. I mean, the prosecution came out and said that Rosenbaum, right, armed with nothing but a plastic bag, was chasing after Rittenhouse, and the FBI infrared surveillance would support this, and that it was Rittenhouse who was the aggressor. And the defense has painted a very different argument. They have independent witnesses to support their argument that it was actually Rittenhouse who was aggressive, that was making threats, that he was going to kill people, that he was using racial slurs. And ultimately, this timeline that this expert is laying out is important. If indeed Rosenbaum, who everyone agrees, at least going into the case, was the best victim for the prosecution, turns out to be the initial aggressor, that will go a long way to helping the defense's self-defense
Do you think that this type of thing is helpful for the jury in explaining all of this? So what you heard from Dr. Black right there, what did you make of that?
Yeah, so not only is he a use of force expert, he's talking about human factors, and that's very important. Obviously, these types of events, they unfold quickly in a matter of seconds, right? We have shots being fired by someone other than Rittenhouse. We have him reacting. And by the way, I mean, I'm not a fan of Kyle Rittenhouse, like for instance, I'm a former federal prosecutor, but the defense is doing a very good job here. And they're really explaining to these jurors how these split-second decisions were made with the best information that Rittenhouse had, and how the mind, body, and our senses react to kind of threats around us. So I thought that this was useful testimony for the defense. It's always kind of how you start and how you close. And this is going to be really probably the last witness this jury is going to hear from. So I think the defense has done a good job throughout this trial. And they did a good job with this particular witness. I liked how they put him on.
We still don't know his thoughts on that. Neama, before we went to the break in the last block, you said that you're not a fan of Kyle Rittenhouse. So how do you think, how do you think this is going, though? You're not a fan of him. So it sounds like you think, do you think that he went there intentionally to do something like this? Or what are your thoughts on this?
Well, under Wisconsin law, I mean, you have perfect self-defense, which is an absolute defense to murder, and you have imperfect self-defense. That's where the defendant subjectively believes that he's defending himself or she's defending herself, but it's unreasonable, in which case manslaughter charges are appropriate. So, or manslaughter conviction. So I think that's going to be the best case scenario for the prosecution here, given how the state of the evidence has come. And I'll talk about those crocodile tears. I mean, I'm here in Hollywood, and I think the Academy is going to nominate him for the Best Actor award. I mean, this is someone that hasn't expressed any remorse over the more than year plus that he's killed two people and should have probably killed a third. But the defense is doing a great job. I mean, really, we have I think, pro-defense judge here, made some pretty inconsistent rulings, in my opinion. But we're really seeing a prosecutor who is desperate. Prosecutors aren't used to losing. And this is a prosecutor who is clearly losing. It's a difficult case. It's a righteous case you got to bring if you're the state of Wisconsin. So, and I agree with Francie. I mean, commenting on the defendant's, Fifth Amendment privilege against self-incrimination, right to remain silent, that's clear error. That's something you're not supposed to do. So I get why people on social media think that he's trying to get the case mistrial. But let's not forget, the defense is moving for a mistrial with prejudice, which would mean that he can't retry the case. So that would be an absolute disaster. That's the last thing you want. The other issue that really upset the judge said it was propensity evidence, right? That's Kyle Rittenhouse a couple of weeks before saying that he was going to shoot shoplifters. I think it was a little bit of a gray area. You should get leave of court before you do something like that. But I don't think it was as clear of a violation as the judge made it seem. Rittenhouse said, I wouldn't use deadly force to protect property, but he's saying something completely different just a week or two before. So I think he had opened the door. But again, things are going really bad for this particular prosecutor.
Going to be successful here? It seems like to me, he's holding this woman as she's dying, trying to help his friend. So I would assume anybody who was in there and witnessed this has been traumatized, incredibly so, by this whole incident.
Sure, there were 16 people in the room, and Angenette, you're talking to a former federal prosecutor turned civil plaintiff's attorney, and actually know Gary Dordick, the attorney who filed this lawsuit. We have some cases together in the interest of full disclosure. So I know this case very well. I could tell you from the civil side, it's going to be interesting because generally speaking, workers' compensation is the exclusive remedy for any work-related injuries. So that's a bar that Gary and team are going to have. Now, there are a couple exceptions. You can sue someone, a coworker, directly. But when you're suing your employer, you got to get out of work comp. And there's a few bases to doing so. One is fraudulent concealment of any threat. And if there's gun a discharge the Saturday before 2 or 3 times, that's the basis for that. Or if the employer was actually the assailant, and that's obviously assault requires some intent, that's another basis to get out of work comp. But I expect the production company to try to get this civil lawsuit dismissed because it is, again, a work-related injury. But I think the civil attorneys, Gary and team, Gary Dordick, they have a lot of good arguments against that. And obviously, there's many potential criminal components of what as well that Francie and Angenette, you and I have talked about at length.
Mid-testimony, I guess. A lot of back and forth over this witness and what he may testify to as it relates to pixels. And so how important is this, do you think, for the state to bring this guy in and have him testify? And then obviously there's this voir dire going on of that witness.
Angenette, I can't help but laugh because this is a bad showing for the state. You want to go out with a bang, not a whimper. I mean, and this is following up yesterday's cross-examination where prosecutors are asking Kyle Rittenhouse about his driver's license, whether he was playing Call of Duty and other shooter video games. Now they're talking about pixels. I mean, you're going to lose the jury. This is a murder case. I mean, I have no idea why they're focusing on this issue. Somehow they're trying to argue that the defense is manipulating the videos and these stills, but it's not going to move the needle. So it's just really kind of a disappointing way to end, in my opinion.
The judge obviously made the right call here by allowing this rebuttal witness to testify.
It's critically important. And let's not forget, even though we've covered every minute here on Law and Crime, when the FBI witness testified, the judge did not allow any audio or video presentation of that particular witness only. So we saw how the defense used the drone video, but not how the prosecution did. So now they're bringing it back on rebuttal, and apparently they're going to argue that it shows Rittenhouse pointing a firearm at Rosenbaum first. That's obviously going to be critical, and we've talked about the timeline here. So really the judge's ruling is correct because these types of arguments that the defense is making, they go to the weight of the evidence, but not admissibility. It should come in, and of course it should be subject to cross-examination if the defense wants to argue that it's inaccurate or doctored or whatever the case may be. That's something they can do. But to leave it out entirely, that would have been improper, in my opinion, Angenette.
Yeah, and the assistant DA is saying, in their view, that this piece of video shows Kyle Rittenhouse lied on the stand. Could any of that change this case, as far as you're concerned, if they get these witnesses on the stand?
Prosecution's only hope to paint Rittenhouse as a liar. When the defendant testifies, the entire case comes down to his or her credibility. So by trying to catch Rittenhouse in these lies, the prosecution is hoping to get that home run and maybe get a guilty verdict. It's going to be an uphill battle, but I like what they're doing here.